Good morning, Councillor DeGenova.
Morning, Councillor Boyle. How are you?
I'm doing okay. How are you?
Pretty good, thanks.
Good. Clerks, I see it's 9:31. Are we all set to go?
Hi, yes, we're ready to go whenever you are.
Okay. And I will, before we start, just ask, I have the control panel remote, but I haven't shared remotely before. So welcome any support on that end from the chambers. Thank you. Okay. Good morning and welcome. This is a business license hearing regarding the Chief License Inspector's decision to suspend the business license issued to, and I'm just going to make sure I get your names right, Daniel Piechuk?
Pietsu.
Pietsu. I was way wrong, but thank you.
Yes, okay.
Daniel Pietsu and Sheena Graham for a short-term rental accommodation at 1351 East 19th Avenue. Before we begin, I have some opening remarks. This hearing is being convened by electronic means as authorized under Part 14 of the Procedure Bylaw, the City of Vancouver Electronic Meetings. As such, panel members may participate in person or by electronic means. Please note that if my connection is lost during any portion of this meeting, we will recess the meeting until my connection is restored. If a council member attending by electronic means loses connection during the voting process, staff are available to get you back online quickly while the voting process is suspended. The staff contact information has been circulated to you. Video of council members speaking and vote results will be projected on the live stream when available. For council members participating by electronic means, in accordance with section 14.13 of the procedure bylaw, please ensure your video is turned on and let the clerks know if you leave the meeting for the purposes of confirming quorum. And we acknowledge that we're on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We thank them for having cared for this land and look forward to working with them in partnership as we continue to build this great city together. Clerks, can we have the roll call?
Good morning. We have Councillor Boyle as chair. And
yes, present.
Councillor DeGenova.
Present.
And Councillor Wiebe.
Present.
You have quorum, Chair Boyle, and I'd also like to acknowledge that the licensees are also on the line as well.
Great, thank you. So we will start with opening remarks from Ian Dixon, Council for the City of Vancouver.
Comments. This is a business license hearing to consider the suspension of the business license that was issued to the licensees who are on the line here. This is the first time I've done one of these in a hybrid way, so I'll try to. I've got some light shining right on my face as well. Your powers to issue a business license are set out in Section 275 of the Vancouver Charter. I don't propose to take you through that. And the Chief License Inspector has the power to suspend licenses, and that power is found in Section 277 of the Vancouver Charter. This is a slightly different situation that bears some explanation with regard to short-term rental licenses and the manner in which they are issued. Short-term rental licenses in the City of Vancouver are issued based on an online application. You simply apply for the license, and a license is issued if you answer all the questions that are given there. The city doesn't go out and review its staff do not review each of those licenses before they are initially issued. But what does happen is that periodically various licenses are audited or there are complaints and they are reviewed. So the structure of the licensing process, that's better. You can see me a little bit better now, for better or for worse. Is that a license is issued initially to the licensee who applies for it, regardless of whether their property or their situation actually applies, is actually eligible under the bylaw. And then the city periodically reviews them, and in circumstances in which staff determine, in their view, that the property or the circumstances don't support a license being for that particular property, the then a suspension is issued by the chief license inspector. And that's the circumstance that's occurred here, is that the 2021 license was issued, and then there was an inspection of the premises, and it was determined by city staff that in their view, the premises were not eligible for a short-term rental license for a couple of reasons that you'll hear from Mr. Miyagi about in a few moments. So that is why we're dealing with suspension. In terms of the decision that you have to make at the end of the day today, is that this is because of the turn of the year. This was a suspension of the 2021 business license, and there is no extant 2022 license at present. If it's your view at the end of this that a license is issuable for this particular premises, your eventual decision would be to allow issuance of a 2022 license, or with conditions if you so fit. As you will see, it's staff's position with respect to this, that this is not a premises that is eligible for a short-term rental license, and there's two substantive reasons for that Mr. Miyagi will inform you of. Just in terms of the procedure this morning, this is a quasi-judicial hearing, and the rules of natural justice apply. The license holder is entitled to hear the allegations against them. They may respond to those allegations, and they may ask questions of witnesses, and they may testify on their own behalf. So all of those things will likely occur this morning. And those are my opening remarks.
Thank you. Thank you, Mr. Dixon. And do you have a witness to call?
Yes. City calls the Deputy Chief License Inspector, Koji Miyagi. For the benefit of all concerned, I will be referring to the documents in the evidence binder, which are tabbed, and just to confirm that all members of the panel and that the appellants have a copy of that of the evidence package. If you don't, please speak up now so that we can deal with that.
I'm seeing nodding.
I can't see anything because it's showing me when I'm speaking, which is not helpful to me. All right, Mr. Miyagi.
Go ahead.
Mr.
Go
Miyagi,
ahead, thanks.
Mr. Miyagi, can you turn to tab 1 of the evidence book in front of you?
Yes.
And that's the notice of hearing for today's hearing, is that correct?
That is correct.
And then at tab 2 of the evidence binder, there's a copy of the 2021 business license that was issued to the appellants today.
Yes, that is correct. And just to note that the name and the address of the property owners are also on the top left there.
So, and then at tab 3, we have an order that was issued to the appellants. And this order is for a city building inspector to attend at the property on Monday, September 27th, 2021. Was this your first involvement with this property?
Yes, although as Deputy Chief License Inspector and Assistant Director for Community Standards, I frequently review case files with my staff who actually put this together and also did the inspections. And so I do have some familiarity with this particular case file. This detailed access order is what we call it. We request this or use this process when an access is not as forthcoming or voluntarily provided. So then we use an order process.
So this order was issued. Do you know why this order was issued specifically?
Yes, the standard process here is that we go to the order process when there is either a delay or some kind of difficulty in obtaining a voluntary access to the property for inspection.
So then a property use inspector would have attended at the property, and at tab 4 of the binder, there's some materials entitled inspection report. Is that correct?
That is correct. So this is the document that the site inspector or the field inspector, if you will, or I should say the property use inspector is the proper term. When they go through the property, they fill out this form, and it goes into fairly good detail of what the property contains in terms of the inspection. And if I may continue to direct, if you go to page 7, or actually, if you look at page 6, the first page, you'll have main floor, second floor. So that's what's described based on what was viewed by the inspector. And then on page 7, you see basement as identified. And so the inspector, in his review of the property, identified or noticed a basement that was developed. And if you look at the commentary below, and we can get into more of the details in the forthcoming photographs, the inspector identified this basement as an unauthorized secondary suite. Um, and in the comments below, it does cite that he had mentioned that to the property owner as well. Along with so when we call it illegal secondary suite, that means the suite was not there, or it's not on the original plans. And we'll get to those information further on into the package. In addition to the illegal basement suite, and when we call it also illegal, it's also work without permit. So it's not zoned for this particular suite to be there, and it's also not been inspected properly, so the proper permits have not been obtained, and therefore the inspections haven't been done, and so therefore arguably it could be an unsafe property without the proper inspections being done. In addition to the suite being illegal, the inspector also noted, if you go to page 8, 2 work without permit constructions outside. It was a rear deck off the main floor, and also a second floor sun deck that was constructed without permit as well. So those 2 things were also identified as illegal non-compliant construction on the site. If you go to page 9, it just cites the violations that formally our inspectors identify. And it says here on the top one, inspection today revealed that an unauthorized suite has been installed in the basement of this 1 FD, means 1 family, essentially, without permit or approval. And then it cites the deck and the sunroom construction as well. So it cites those 2 other violations. Page 10 are the pictures of the property. And I'm going to fast forward right to page 19. If you go to page 19 as part of the inspection report, you will see number 20. That's the lower photo. That's the door that starts to lead into the stairwell into the basement. And really the interest of the panel today and for the secondary suite activities, it's the basement. You'll see on page 20 just some photos of how you access the basement. And then on 21, you'll start to see how the inspector has started to view the basement in terms of his inspection. It shows a number of bedrooms, a bathroom. On page 23, it shows a kitchen. And also an external access that I believe that leads outside, which is photo 28. Page 24, you see a fire extinguisher and a fire exit plan for the basement. Those are requirements for the short-term rental activity, so it's good to see those in place. And then I'm just gonna these other things about the sun deck and whatnot, these are also illegal, and so therefore they were photos were taken of those. What's of interest, I'll advance you to page 28. You'll see photo number 37, and that is a zoom up of what we have on plans, what the city has on plans for the basement, which is, you can see there clearly that it's supposed to be unfinished. So had there been permits issued and whatnot and properly constructed, that wouldn't appear as an unfinished basement, but it would appear as a permitted suite with all the, however, it would have been designed. And just to show that the photo 38 it's kind of flipped over, but that is the layout of the basement currently. However, the photo 37 is supposed to be what is in place. So clearly, the inspector has identified that this is a unlawful secondary suite. The other photos just verify page 2930. It just verifies that these construction has not been documented, no permits, and so therefore the plan once again identifies that it's supposed to be an unfinished suite. Mr. Dixon,
So yeah, and then over at so having observed all of that, what conclusion do you reach with regard to the eligibility of this this premises for a short-term rental license?
yes, through the chair. Inspections are very powerful tools for us, and we do frequently go out to various secondary short-term rental locations to verify various activities and confirm what's out there. And it is clear to us that through documented means and also visual inspection retained by photo, that that the suite is not supposed to be there according to the plans. It's not, the property hasn't been properly zoned for that as well. And so we do conclude that it is a illegal secondary suite amongst a couple other work without permits that's been identified. And so based on this inspection and in this, in this particular case, for this inspection alone, we have fairly clear evidence to say that this particular secondary short-term rental is not, should not be occurring in there. The bylaw clearly states that no short-term rental should be operated in an unlawful dwelling unit. And that's a fairly clear section in the bylaw. And in our case, we were able to determine that.
So I just want to pose a hypothetical. Presumably, this suite could be regularized and brought into compliance if the appropriate permits were taken out and the zoning was appropriate, which I believe it could be. So it could be, this suite could be legalized, correct?
Through the chair, yes, I presume it could be. Now, it would have to be still approved through different mechanisms beyond myself. However, there are application processes that may lead this particular area to be legalized.
So I'm just going to ask you, if it was legalized, would it be eligible for these, for the appellants to run it as a short-term rental?
And unfortunately, it would not. If it's legalized, the property owners would have to prove that they live there. They live in that suite. And it's clear to us that they live upstairs in the second and the main floor. Short-term rentals, one of the primary requirements for short-term rental is to have this activity in your primary residence. So for them to legalize that particular suite, which they, I believe, would have the option to do so, they still would not be able to conduct short-term rentals there themselves. Perhaps renters that go in there might be able to take out a license and rent it as their short-term rentals, but not the property owners in terms of how they are residing now.
And part of the reason why we would consider this to be a separate dwelling unit is the kitchen. Is that correct?
Yes, the kitchen would be the primary identifier.
And I'm just going to take the panel through the remaining materials that are in here. I'm not going to dwell on tab 6, as that's the appellant's response. Tab 7 and 8, sorry, tab 7, these are photos taken from Airbnb, a screenshot taken of an Airbnb rental for the basement suite. Is that correct?
That is correct. So these are the pictures of the basement, and it's identified in the listing as the entire suite is available.
And then at tab 8, what's this document?
Tab 8 is a is information that we obtained from a third-party provider that allows us to get an indication of what the booking activities has been at this particular listing. And so if you go to the lower right-hand corner, it's got 3 documented stays in September, 4 documented stays in August, 2 in July, so on and so forth. And if you flip the page, it has a whole list that goes all the way down to January of 2022. This allows us to determine that there's been a fairly good activity there, and it's booked out relatively regularly, month to month. And then it was removed in October 2021, I presume, because of the suspension. But yes, that's what that information reveals.
Do you have anything further to add, panel?
Just to say that this particular one, we did not do an audit step, which is to interview the property owners. And the reason why we don't do that, once again, is because if the evidence is very clear to us through an inspection that this is a breach of the bylaw, and in this particular case, there were breaches of the bylaw determining that it's an unlawful suite. So to administration, it is a fairly a clear violation, and therefore the short-term rental activities would need to cease there. Thank you.
That's all the evidence on behalf of the city. Oh, I'm
Okay,
sorry.
thank you. Oh, go ahead.
I'm sorry. I kind of cut that off there, but of course, I believe the next step is that there's an opportunity for the licensee to ask Mr. Miyagi questions.
The next step I have is that panel members can ask questions of Mr. Miyagi and then the licensees. So I will go next to Councillor, either Councillor DiGenova or Councillor Wiebe, if you have questions. And it may be, I see Councillor DiGenova on the list, so go right ahead.
Thanks, Mr. Miyagi. I'm just looking at, and I'm sorry, my tabs aren't exact because I'm looking at a PDF document here. But in looking at the listing, it says the entire residential home. So what I understand from you is that there's 2 separate residences, and that's how your staff would consider it. But considering the listing says the entire residential home, is that in compliance with the short-term rental license?
Through the chair, the listing shows pictures of the basement, and so therefore we conclude that when they say it's an entire home, that it's the entire basement suite. We didn't see any photos of the upstairs, the secondary, the second floor, the main floor, so we didn't assume that the license, or although the license is at the main house, which means the main floor and the secondary floor, the advertising information points to the fact that the main house is not being rented, but it's the basement suite. And we also obtained information from the property owner during the inspection that's the activity that he does, is to rent out the basement.
Okay, thank you very much. That's all from me.
Okay, thanks, Councillor DiGenova. Councillor Wiebe, you are up next, and I'll put myself on the queue after.
Yeah, my first question is, can this be a multiple dwelling unit under the RT10? And so could the owners put their names on each one of the dwellings, recognizing the zoning that they're currently in?
Through the chair, they would, for the purpose of short-term rental, they would have to show that they live there. And so if the paper documents say that one person owns one part or one suite and another person lives in another or owns another suite, that's fine. But through the short-term rental process, we do need to determine that these individuals are residing in their primary residences.
Okay. Next question. Looking at the real estate listing, when purchased, it talked about a renovated 2-bedroom suite downstairs. What is the process for a new property owner when they've purchased a property that has a suite already installed?
Uh, Through the chair, these are processes outside of what the city controls. Uh, as an opinion, we would strongly recommend individuals to check the listing information for it to be correct. And if there are suites built into the property and it's identified as legal or just suites, the property owners or the buyer, potential buyers, do have the opportunity to check with the city to see. And these plans that I've shown, the inspectors have shown where the original plans that the city has, and that's what is deemed as legal for that property. That's available to the public, and so they can easily obtain that. The realtors should be able to obtain that as well, and so therefore, those steps is what would be recommended to prevent any misunderstandings when individuals purchase a home.
So when they have purchased the home, what is the next step that you would expect a property owner to conduct?
I think to be prudent and it's a buyer beware kind of a scenario. I
I
would
understand that, but you've purchased the property. It's got a beautiful 2-bedroom suite downstairs. What do you expect a property owner to do?
verify that it's legal or not.
And then what?
Well, I guess I can determine what the property owner is going to do with that suite. If they choose not to secondary suite it, then they don't need to do anything necessarily, and just leave it if they wish to do so. But if they intend to occupy it in any particular ways, whether renting it long-term rental, so depending on their activity, they would need to take the legal steps to make sure that that particular space is legal and done safely with the proper permits.
Okay. Did you see any life and safety issues when touring the suite?
The inspector did identify that it's an illegal suite. So to us, uh, when it's work without permit, there may not be blatant life safety issues like low ceilings or access, but because of the fact that it's work without permit, we would deem it uh, uh, not safe, if you will, until the proper inspections have been done.
Okay, that's fair. Thank you. That's all my questions.
Thank you, Councillor Wiebe. And I have a few questions myself, though a couple of them were just asked by Councillor Wiebe. I am curious to just better understand the options here. So the basement suite is an illegal or non-compliant suite. Could the homeowners rent it out to long-term tenants, as the documents suggest has been happening for many decades?
Technically, as it stands now, no, because it still needs to be, it's a work without permit, so that needs to be permitted. Once that's legalized, yes, they could rent it as a secondary long-term rental if they wish to do so.
Okay. But we know there are many secondary suites that aren't. I mean, it's been rented for a long time. There are many secondary suites around the city that are that exist in this sort of gray area. Can I just clarify? I guess I know this. I understand the rule is it needs to become legalized, but there isn't a licensing process for a secondary suite like there
Yes.
like for a long-term rental like there is for a short-term rental. So it would be a
That's actually not correct, Councillor Boyle. There
okay.
is
That's why I'm asking.
secondary suites do require a business license. All
Okay.
secondary suites are required to be licensed in business. You're correct that that there are lots of quote unquote illegal suites that are rented throughout Vancouver. They are contrary to the bylaw. So from staff's point of view, Obviously, if we don't find them, we're not actively looking for such suites, but once they come to our attention, staff's attention, it is the obligation of city staff to enforce the bylaws as they exist. So it's not a gray area at all, actually. They're work without permit and illegal suites and are contrary to the bylaw. So if someone were to come in to ask for a business license, which is also a requirement for an illegal basement suite, the city couldn't issue one. Because that's contrary to the bylaw. It is a long-term difficulty that we have with these quote unquote illegal suites. But from a staff point of view, when they come to our attention, it's not a gray area. It's simply it's an illegal dwelling unit.
Okay, appreciate you being so clear on that. My last question is another question of clarity under the short-term rental bylaws, that the main and upstairs floor as the primary residence could be rented out periodically if the homeowners were going away for a week, or like, just to clarify that there are still options for short-term renting that primary residence periodically through the year, and that would require a new license, but would be viable?
Yes, through the chair, if they were to have short-term rentals occur on the main floor or the second floor, so the legalized units, and it's clear to us that that's where they live, yes, they could get a license for that particular space and short-term rental those spaces.
Okay, and if the decision from the panel today was to refuse the business license for short-term rental for the basement, does that still allow an option if the homeowners were to decide to periodically short-term rent the upstairs, which is their primary residence? Or would our denying the business license because it's for the whole address today eliminate that option?
The problem is the work without permit, the multiple work without permit that's been observed. As a general rule, we don't issue any short-term rental license to a building that has work without permit because we simply just don't know what standard that work's been done to. So it's a safety issue, potentially.
So even on the second and top floor, because of the porch and sunroom, a short-term rental license wouldn't be allowed on those main and upper floor until that work was inspected?
Correct. The work without permit would have to be corrected, and then we would then review the property again and see.
Okay. I will leave my questions there. Councillors, just checking to see if anyone has any other questions before I move on to questions from the licensees. Okay, I'm seeing heads shaking. So next, do the licensees have questions for the witness?
Yes, thank you very much. So Koji, you had mentioned in the very beginning there the order was provided to us, and you had remarks around it was the order states 3.1.6 section, which is a very generic statement of obviously city having rights due to our short-term license to be on our property. And you had mentioned it was due to those types of notices being sent out for difficult access or non-forthcoming owners or rental or owners. Did you have any more additional information to provide on what actions were done previous to providing the notice on contacting the owners?
Through the chair, when we issue a detail access order, that's usually the case. And so I am aware that standard procedures will require our clerks to contact the property owner to gain access to set up an appointment. And similar with our property use inspectors. Failing to achieve a particular date is when we resort to an order.
But what was the difficulty that was experienced by the inspector? We aren't aware of any difficulty. We would just like to understand that a little bit more.
I could only assume that perhaps there was a delay or there was not a conducive opportunity based on people's schedules.
No, what happened that didn't happen? Okay, thank you.
You had mentioned that, or through much research after this event has occurred, obviously the city stance on short-term rentals is, we don't care unless we get reports or if we have a random audit. Can you mention to us how this notice came about? Was our residents based on this random audit, and how did that come about?
Yes, so we have a number of procedures that we do to research bookings or research listings. And in your particular case, I would have to say that, and I can't say specifically because we do a number of these, but when it comes to our attention, it's through the means of either complaints, which in your particular case, we may not have had that, but our staff did the research and we saw the basement. My understanding is they saw the basement postings, but your property was your license was identified for the main and the second floor, the main house, and so there may have been a trigger to there. I can't say exactly what triggered them to do that. We have thousands of case files that we look and see, so it's not a particular zoning in on a particular individual per se. We come across many of these, and then we happen to review a number of them. And the steps that are taken are what you saw here, where we make contact and say, can we see what's happening? The other trigger may be that we also look at bookings as well, and you have booking activity every month. And so therefore, we also look at that as well. For high booking properties, that's a trigger for us to take a look and see if it's a commercial type operation.
Okay, you're mentioning commercial type operation. What defines a commercial type operation?
It's just an administrative term that we use, and it's a suite that is booked fully without a principal residence, and it's done in many ways to essentially have no primary residence, or that it's a very high booking, so therefore it's financially driven. Yeah, so those are some of the administrative terms that we use.
Okay, and as you had, the city presented evidence 7, Airbnb listing, and also you had mentioned your staff do research, obviously on high volume listings. So you were also in the possession of evidence 4, which was the building plan, which without an actual inspection on the property, you would be aware of the bylaw violation of section 6.4 of the zoning and development bylaw 3575, which is ultimately what was mentioned on the inspection report as the primary basement unfinished. Was your department aware of this prior to sending the notice out?
Prior to the inspection, sorry, if you can clarify a little bit more what you're asking me.
Yeah, what I'm asking is that you obviously have mentioned that you look at Airbnb listings, you have access to the photos. For me as a homeowner, I was made aware by the inspector that a suite as defined by the city is one with a range or a stove. When I think of a suite, I see a suite as a a compromise of rooms together that are obviously on a floor that comprise of, let's say, this listing. Airbnb only allows you to put in entire home or rooms. The fact that we have a living space as well as a bathroom and bedroom, it was listed as entire home. The intention there was not to necessarily say that we are obviously Airbnb the whole house. And I will get into some of our evidence later on a bunch of factors there. But what I'm saying here is evidence 7, Airbnb listing, you knew that there was a basement suite that was not unfinished. You also had access to the building plans from the city, dated in 1973, 75, of that nature. Without an inspection, you would be aware of the possible violation of 6.4. The notice stated 3.1.6, which gave us as homeowners no idea what you were intending to do with your inspection. So I'm asking you, were you aware of the violation of our basement suites based on 6.4 prior to the inspection?
The standard procedure for property use inspectors is we go on site, we observe what we see, and then we do the research to see if it matches what we saw.
So property inspectors do not have access to these building plans prior to the arrival of the date of the inspection.
No, they have access to that any time. What I'm saying is procedurally, we won't necessarily go and do a pre-look necessarily. It all depends on the inspector and what they need to do. As standard process, we need to compare. So, so in this particular case, I can't speak to what Vince did as his necessary step. What I do know is that or not proper, but property use inspectors will, as practice, take a look at the site first, see what they see, and then compare it to whether that is in compliance or not.
Okay, thank you very much for that. You had also mentioned that our property is not zoned for a basement. I'd like to clarify what you mean by zoned, as it is an RT10 lot. So taking into consideration that, yes, the plans of this basement is unfinished, something we'll talk about a little bit later. But taking that into consideration, taking that off to the side, are you, by making that statement, are you saying that we would not be able to have a basement suite whatsoever due to the zoning? Because when you say not zoned, you're saying, because in the city map, which I have I apologize, I was not aware how I can send the evidence that we have here, but I have a screenshot dated around the time that our notice was given of the city map that you can access. It says we're a RT10 zone. It also states that we're a 2-family dwelling classification. So I'm just trying to understand, it seems that, you know, the city in how it's being classifying our property amongst BC assessment, the city resources, it seems muddled. And for that fact, I just want to be clear. Are you saying that our zone would not allow for a finished basement suite to be there?
So what I stated is that you are currently not zoned to have a secondary suite in the basement. It's 1 FD, and so you would have to have you would have to have it zoned so that you now have 2 suites on that particular lot. Right now, you're zoned to have 1. That's what I said. I didn't say that you're not zoned to have a basement because many properties have a basement. It's the secondary suite that's the issue here.
Okay, and how would you define when it comes to the fact that we have a staircase connecting all floors with passageways, doors, as noted in the inspection report on page 8, noted that obviously all smoke and CO detectors, fire extinguishers on all floors, no keyed locks on bedroom doors. I believe also the staircase is on page 7 stairwell southeast corner of the house. So you're looking at this as a secondary suite, and this is a one-family dwelling. So this is our principal residence with a staircase with no doors, blocking access. Well, there's doors, but they're passageways, no locks. So in that definition, would we be able to short term, if we were to obviously make this basement suite finished, approved, and all that sort of stuff permitted? And also something that I just learned today that obviously I was not aware, that all of the sun decks, which obviously, yes, I understand is a safety concern, but is not necessarily directly correlated to the basement suites. Once we have all the work without permits done and the basement suite permitted and everything, if we had this as a staircase as a principal residence and they were just rooms within our house, would we be able to short-term rent?
The interconnectivity was placed, I assume, in there because the basement is unfinished. The quick answer is you have a suite in there with a kitchen, and so therefore that makes it into a secondary suite. And then, as you mentioned, all the work without permit would have to be corrected if you were to turn that basement into some kind of a space beyond the unfinished original plans.
Okay, so just to clarify, because this was something that was mentioned by the inspector, a kitchen, what denotes a kitchen? Is it because of the range? If the range was removed, work with permits were addressed, the unfinished was permitted, would we be able to short-term rent?
You would have to remove the kitchen. I don't have the definition of what a kitchen is here, and unless Mr. Dixon's got that. But I would say that if your renovations down there is done legally and in compliance and meets the definition of not a suite or a secondary suite, but just a finished basement, then perhaps that's something that we would look into as one unit.
Okay, so you don't have available what would denote not a secondary suite, because we are aware of that now, that secondary suites with ranges, as was mentioned by the inspector on his arrival, was what was the impetus that we were suspended. He had mentioned that the range, if removed, would allow us to short-term rent if we could also address the compounding factors that we have here, which is an entire basement that was done probably 40 years ago. But unfortunately, as owners, we are now going to have to deal with the brunt of that whole fiasco. So are you able to clearly define and state to us what would allow us to do short-term rental downstairs?
I think that that's beyond the scope of today's hearing. Madam Chair, I mean, that is a complicated question that would require, there may be a development permit required. There's a number of steps that have to be done, and suggesting at this juncture that that there is no way to make it, what the exact criteria for making this into an eligible space is kind of beyond the scope of what we're trying to decide here today.
Okay, fine. That's fine. I'll move on to another question, Koji, that I have around the inspections. What does the inspections usually pertain when it comes to actions done on property? What is the process, the steps involved? Can you provide those details?
Again, I'm not sure how that's relevant to the question of there was an inspection here with regard to this property, and the question before us is whether or not the suspension was appropriate. The suspension was appropriate.
Okay, I understand. Apologies. We've just been trying to figure out what we're supposed to do, and we have not been even given access to this report until this hearing was scheduled. We've asked questions. We're not sure what we can do to kind of to remedy this. So that's why I guess we're here. So
One last question, Koji. I had talked to the short-term rental department. Would you be able to make any comments on the following? I was informed that, well, one of the processes that you guys have in place is that immediate revoking of the license. And we'll talk a little bit more about how that is very disconnected from obviously the work without permits and the other zoning and development issues. But what was mentioned to me by short-term rentals is that, and one of the steps that you do is that you ask for the Airbnb listing to be removed immediately, which obviously we did, and we have not done any short-term rentals. We have abided by everything that has been asked by the city or provided at this time, which we will go into detail. But what was mentioned to me is that we could short-term rental if the definition, if let's say a future, we could short-term rental, if the stays were 30 plus days, we could use Airbnb as a platform to do long-term rentals. Is that correct?
So once again, the 30-day is a long-term rental, not a short-term rental. You would still need to abide by all the regulations that exist there, and you would have to get a long-term rental license, and then you would have to make sure that the suite is legal. So I'm not sure what exactly was relayed to you, and I can't speak for every clerk that you've come in contact with, but the general underlying statement is correct, where if all things are legal and you maintain the suite, yeah, the option that you'll have includes doing a long-term rental if you were to legalize that suite. Because if you legalize that suite, you wouldn't be living there primarily as the primary resident. And so therefore, a long-term rental would be the most reasonable option that you would have. I think they're just trying to be helpful.
Thank you very much. That would be it for us.
Okay, thank you for that. So we'll now move on to opening remarks from the licensees. And then any witnesses, if you have any witnesses.
And just a point of privilege, Chair Boyle, I can't remove myself from the queue. I'm not sure why I'm on it, so I apologize, but I'm not on the queue currently.
Okay, you've been removed, but thanks for flagging that for me, Councillor DiGenova. So back over to the licensees.
Thank you very much. Thank you, council members, for hearing our case on this matter. We are aware that short-term rentals are a sensitive subject in this city, and we do understand that the city has a hard job ahead of themselves to rectify this. We are grateful and proud to be homeowners in Vancouver, and it is a great accomplishment for us to achieve. We come from backgrounds where owning a house was the ultimate goal. I come from a Polish immigrant family, first generation. My wife comes from a single mother family. We moved in May 2019 to the house that we currently live in, 1351 East 19th Avenue. We applied for a short-term rental in December 2019 and have been able to go through the unfortunately quite easy process of getting the short-term rentals. But we've always been able to abide by all safety standards and guidelines provided as noted by the inspection report, that we have everything that is needed to have a safe home for ourselves and for guests. We used to live in a condo in Mount Pleasant and had both our families visit from Victoria often. This is why we have decided to do short-term rental. It is not for commercial purposes or financially driven means. However, with COVID and the loss of my wife's job, it did help to alleviate our financial situation. Although we do enjoy having people around the world visit and stay And that has always been something that we take great pride in.
Ultimately, though, the reason we purchased this house and pushed ourselves financially to get into this was because we were having a child. We wanted to have our family be able to come and visit and be comfortable in our home. And so the primary use of our basement is actually our own use. During COVID and when I lost my job, like Dan mentioned, we decided to short-term rent the basement out to make ends meet. Since people weren't really traveling, we were able to help people who were coming and having to quarantine in this country. They would stay for 14 days, things of that nature. So primarily, though, the use of our house, we use all of it.
And so to just to establish that this is our home. This is our principal residence. We pay no empty home tax. We have a basement suite, however that is defined, a set of rooms that both our families can come and visit. We used to, when we lived in Mount Pleasant in our condo, pay for hotel rooms for our families to stay during holidays. And so, yes, we pushed and we saved and we made it possible for us to own this home. The unfortunate nature, though, that we're in, as you can see, is that we are now, unfortunately, visible to the city on so many counts. And as I want to mention as well, is that we moved in May 2019. I guess a question that I had forgotten to ask Koji was the fact of, as a homeowner in this competitive market, and these plans or these papers that you as a homeowner should have access to prior to making a bid on a home, I would like to understand, like, how long does that actually take to get all of the proper papers? Because from the many sources, from BC Assessment, from the city's map, the zoning of this house saying 2-family dwelling, saying 1-family this, it is a job in itself to be able to buy a home and be entirely sure that you are buying a home that has everything that is permitted and understood to be lawful. So we understand that there are things that need to be corrected. And when we get to a bit of our statements and our evidence, hopefully we will be able to highlight that we are homeowners that are willing and wanting to know exactly how we can make this right. But the city has not been forthcoming in providing the details. As was mentioned by my wife, is that the inspection report, having this appeal process, has given us access to this report and the violations within.
Prior to that, prior to this hearing and prior to a week ago, we had never seen that report despite having phoned and asked for it and emailed. And also upon applying for my short-term rental license in the December of 2019, January 2020, I phoned the city clerks and spoke to them on multiple occasions about this, trying to make sure that we were actually eligible for this. That's it.
Yeah, with that said, I know that the agenda says opening remarks from us, and then the next state is calling witnesses. I just want to, I just want to clarify, will we have an opportunity to discuss some of the evidence that we have or other details in this matter?
Thanks for clarifying. I was just going over the agenda to make sure I understood. So this is the opportunity to do all of that. Opening remarks is brought.
Okay.
This is the moment. Yeah, thanks.
Okay, thank you very much, Chair.
I actually, sorry, Madam Chair, if I could just cover, I actually think it's best if it's split into two. Is that I would take it that they've made their opening remark now. Then the way you would normally do this is that that someone would then testify to whatever evidence they want, and then that person would be subject to questioning after that. So it does make some sense to have it as two separate phases.
Okay, understood. So that was an opening remark. We'll move into calling of witnesses, but and that is the section in which you can present evidence, other arguments, and then the panel will be able to ask questions of that, as will Mr. Dixon as well, and then we move to closing submissions. Is that more clear?
Yes.
Okay.
Unfortunately, I'm not a legal professional, but I think, I think that should be fine. We obviously have, our side that we just want to make sure that we are able to point out some key events on the timeline. So as long as that's provided, then I think we should be fine.
Yeah, so we'll move into that section now. You continue to have the floor, but not as opening remarks as putting forward your arguments, and then the panel will ask questions. So you can go ahead with that now.
Okay, great. Thank you very much. So obviously the order of inspection was sent on August 20th, 2021. Just to state that was the first ever contact within the city that we were provided. So there was no clerk that had tried to call us to establish any time. It was a paper posted on our door, legal notice, telling us that based on a very generic statement of 3.1.6, that the city would come and inspect. Starting around October 20th. We're not October 22nd. Excuse me here. Yeah, so in August 22nd, we had contacted Vincent, the property inspector, a few days after providing that legal notice. He had informed us. I had asked, what was the intention here? He informed us that this was a safety inspection, and that there was a bunch of requirements based on Airbnbs to help to obviously facilitate the safety of the space. We had talked in great detail about the fact that we would have to have interconnected smoke alarms, fire extinguishers, exit map, contact details, emergency details, things of that nature. That was what was given to us as owners as an explanation for this inspection, the scope of the inspection. However, I pressed further to understand one comment that was a bit flippant, which was, oh, and there will be some plans addressed. So I had asked what he meant by plans would be done, and that's when he informed me that he would be looking at some plans within the city that they have access to. I had at that point on August 22nd or so informed him that we had actually submitted, since living here in May 2019, we haven't had the opportunity to request, and we were curious what the city had for building plans. So we had an open request for building plans with the zoning and development, which was at that point in time in August 2021, was a couple months of waiting. We had received those inspection or the building plans on August 31st of 2021. So we were unaware that we had an unfinished basement until August 31st, 2021. The inspection was to occur September 27th, 2021. So we've done our diligence in obviously understanding what the inspection was. We were told it was about safety. We were then made aware that this was going to be more than that. And we were aware that we had this unfinished basement to deal with. So we allowed the city to come on September 27th. We had not given the opportunity. So the inspection happened. We gave access to everything. I'm just sorry.
We never received the report, and so my husband contacted Vincent sometime after the inspection, and we were told at that point that the inspection report was in draft format, and as such, we would not receive a copy of the report until it was finalized. And so when we asked him, how can we move to next steps? How can we fix any of the issues? Aware now that our basement suite was in fact not actually legal, we've been given no recourse until a week ago as to what we can, and we still haven't been, we've just been given access to the report and what was said about us. We've been given no recourse to fix the problem.
Yeah, so we only received the obviously the revoking of the short-term rental on October 7th. The preceding weeks, coming weeks, we reached out to short-term as well as Vincent. I was given verbal, I was told by short-term to talk to Vincent. We talked on November 4th of 2021 after some emails were exchanged. I was informed on the phone that the report was in draft form. The contents of the reports itself that I would not have access to unless I request an access for the report via the Freedom of Information Act to get it. And he also stated that due to the city's position on short-term rentals, it was noted that all these inspection reports that have culminated from these short-term safety inspections were stuck in limbo for an indeterminate period of time, even though the cancellation of the licenses were swift. Following that conversation and to this date, we have not received any report or any formal violations from zoning and development that would allow us to proceed with being able to correct and rectify what is wrong with our home, to be able to commence short-term rentals.
Or even bring our home up to code as required, because we don't ever really intend to long-term rent our basement suite because it is part of our principal residence that we use on a regular basis.
Something else that was noted as well in the inspection by Vincent, and unfortunately, I was not aware if we were able to call on witnesses to make them present here. But in the conversation with him and looking at the basement suite, we had discussed the age of this suite, and he had noted, which I had commented here, that it looked most likely 40 years old, most likely done after the last permit was done, which was only for a sun deck in 1973 or 75. My memory eludes me there on the exact date. As mentioned, we followed all safety guidelines. The premise that this was a safety inspection primarily, I will state that in the inspection report, you will see that there will be no photo of a fire extinguisher on the top floor. There's pictures of all the smoke alarms and fire extinguishers. I do have evidence of a fire extinguisher that was present and still present on the top floor. Yeah, so outside of that, also in the inspection report, something that we have learned is, and I kind of mentioned as well, that we have all the safety regulations and requirements in our premise. This is a 40-some-year-old unit or finished space in the basement. This house is 114 years old. It's been owned by multiple families throughout. If safety is a concern, then I would like to understand what that actually means in the terms of our work without permits being sun decks in a fully finished basement suite. There are no bars, there are no locks. We purchased this house because the finished basement suite looked professionally done. I do understand that obviously there's no permits and we have to go through that process, but knowing that we have so much to work with the city, and the city has not provided us any details of our violations. Anything that we do submit would be it possibly changed on us midway through the process if we were to try to make this into an entire one single family dwelling house, for instance, because we do have the staircase, which many houses in Vancouver do not have. And as mentioned, our family do stay there and have access to the whole house.
And the thing is that one of the issues we take here is that we were told that we received this notice. It was very broad. It was not defined. When we phoned to seek further clarification, we were told this was a safety audit. We have a very high rating on Airbnb We have no complaints against us. Our house has been standing for a very long time, is very safe. And then when the inspector came in, he actually wasn't here to do a safety inspection. And that was very obvious. He was not interested in all of the fire extinguishers and all of the safety features that we have in our home. It was very clear that he was here to do some other inspection, which was ultimately to shut us down as a short-term rental. And that was the entire goal of why he was here.
I think in conclusion, as I've mentioned, we have not received anything formal, only verbally through draft reports. We don't know where our inspection report lies within the city. Yes, we have certain things that we need to address. That means that the short-term rental license is in question here, but we're hoping that what we can provide is options that allow us to continue functioning the way that we are as we navigate the waters of trying to figure out how to rectify all of these. As mentioned, it was very swift to lose the license. It was not swift in understanding what we needed to do to rectify this. Yeah, I believe really the stairways connecting all floors, including the basement, this can be a one-family dwelling. We can remove the offending range and whatever is defined as a kitchen potentially. However, what we were told by the inspector was if we remove the range, we would no longer have this as a suite. This would just be rooms within our home that we could be able to use for our families as well as for short-term rental. Yeah, I think that's all we'll say at this point in time. Thank you.
Okay. Thank you. And panel, we will move on to questions. Councillors Wiebe or DiGenova, do you have any questions? I see Councillor DiGenova first on the list, so go ahead.
I do. Thank you, Chair. And thanks very much to both of you, to the applicants for coming today and for also bringing your questions. Sitting on business license panel hearings, I understand that there can be some confusion, and I appreciate what you've shared. My questions for you are, do you realize that after a decision of this hearing, there is nothing that's saying right now that you can't, that precludes you from moving forward with rectifying those issues that you had mentioned? So are you aware of that you can still do that?
We are, I
Afterwards?
guess, but we hadn't received any documents to say what needed to be done to rectify it.
Okay. And are you aware that that process would come after this process? So this process would have to happen first? Is that something that you
No, we were
understood?
not. No, we were not understanding that.
And
As you can see, we've done a lot of research.
I can, and I'm sorry, because we do sit in a quasi judicial body when we consider these business license when we consider business license matters, I have to ask you questions, so it can't just be comments at this point. But are you aware that with the short-term rental license, you would have to be renting the portion of the home that you consider your primary residence and that was considered your primary residence? So that could be possibly your suite, depending on what the definition and if it met all of the compliance with the bylaws. Are you aware of that? That as long as it was your primary residence
Yes.
as well? Okay. So those are my questions right now, Chair, and I will leave it there for now.
Okay.
I see Councillor Wiebe also on the queue.
Go ahead, Councillor Wiebe.
Yeah, just a couple quick clarifying. So prior to seeing the notice on your front door, you had no contact from the city. Is that correct?
None whatsoever.
No, we had just gone out for a quick walk with our daughter, came home and found this notice stapled to our door. That was our first communication.
And there was no process for you to fix once you heard that there was a violation, there was no period of time for you to be able to fix the violation
We've
before
never
coming
received,
before us?
sorry, we've never received notice of the violations until we got the documents for this hearing.
Or the ability to remedy them?
Yeah.
That is correct.
Okay, and you also had no ability to call witnesses, is that correct? Or you didn't know that there was an ability to call witnesses?
I had emailed Ian Dixon yesterday asking him the structure of this meeting. I was sent actually this morning the opening remarks and all the sections, but I did email him yesterday asking him the structure because we did have evidence, as well as potentially we would have liked to have called Vincent, the property inspector, on this call. But unfortunately, that is something that, I missed.
Okay, thanks for that. Next one, when the safety audit was done, did they do a safety audit of the whole house? So did they check life and safety, like you said, for fire extinguishers on all levels of the house? And
They did, except missing obviously the top floor extinguisher, but he inspected all floors. He had access to everything on our property. We did not impede. Also, we provided photos, and I noticed in the inspection report, it says photos taken, yes, no. There was no consent provided by the inspector when he came in here. He just said he would be taking photos. So we weren't going to obviously, impede that. But yeah, he's checked everything in this house.
But
okay,
he did miss, he did miss the upstairs.
Yeah, I mentioned that. Yeah.
Okay.
Thank you.
Thank you very much.
Thank you, Councillor Weeb. Councillor DeGenova, I see your name back on the list. Do you have?
I was wondering if now would be appropriate for me to just direct some clarifying questions to Mr. Dixon, Chair.
So next is Mr. Dixon asking any questions of the witnesses, but I'll clarify when the moment is for that to happen.
Yeah, I don't have any questions for the appellants.
Okay, thank you, Mr. Dixon. And can I clarify with you or the clerks if or when there's an opportunity for panel members through the chair to ask any further questions of City Legal Counsel?
Now would be appropriate.
Okay, then Councillor DeGenova, I will forward you on the speakers list to do that.
Thank you very much. Thanks very much. Through the chair, just wondering, is this process the way that we would typically see a process happen, where a decision would have to be made on this matter before the applicants could move forward to rectify anything that possibly could put them into compliance to allow them to move forward in obtaining a business license?
Yes, because the business license can't be extant whilst there's work without permit. That's a hard stop from staff's point of view. Once that's rectified, the license can easily be issued. But at this moment, the city cannot allow, the bylaw doesn't allow for an unpermitted dwelling to be occupied as a short-term rental. So the license has to be suspended because it doesn't qualify right now. So it would have to be immediately be suspended. Bringing items into compliance is, I think I can clarify a couple of things that have been said. I don't know why the inspector referred to it as a safety audit. The city has the ability to inspect anyone's property at any time for any reason, and so the reasons for it are often not provided, and there's no legal requirement to provide the reasons for an inspection. And I don't know why it was described the way that it was. And all inspections are the inspector is supposed to observe everything that they can. It's not the city's general process to set out chapter and verse as to exactly what needs to be done. The process would work the opposite way around, where the homeowner comes in and proposes, I propose to do this work in order to resolve whatever issues and obtain the necessary permits. the comments that were made by the inspector about it being drafted and being caught up, that I believe would be with respect to, and I'm sure that the appellants don't want to hear this, but it is open to the city to prosecute them for that work without permit, despite the fact that they didn't actually do the work without permit. Now, it's unlikely that that would happen in this circumstance, but it may be that process that is in terms of the inspection report being in draft and being withheld for a period of time. And caught up in the system. So those are just possible
So I do have a couple more questions for you.
Yep.
I'm just wondering, just to clarify, because I have been on these panels before, as have you, Mr. Dixon. I'm wondering if you could clarify also that there is no accusation that after they received the notice that they have continued to operate outside of compliance. There is nothing being brought against them saying that that's what they have done since that time. Is that correct?
That is absolutely correct. The only issue here is whether or not the premises themselves are eligible for a short-term rental license as of today, not whether they will be in the future.
If their business license, another question, sorry, follow up through the chair, was suspended today, that would be procedural matter where it would not in any way prejudice whether or not they could get another permit if they came into compliance. Is that correct?
Absolutely correct.
Okay, I just wanted to make sure that I was understanding that, but also I could ask some of those questions, perhaps of you that I have.
And perhaps if I could
I was hoping might clear that up.
So perhaps if I could clear up, because it is slightly procedurally odd at this juncture because of the change of year, is that the decision that's actually under appeal here is the suspension of the business license that occurred in 2021. So the decision of this panel would be either to uphold or overturn that decision for whatever reasons. If at that point, if it was upheld, it would be fairly obvious that the 2022 license wouldn't be issued until the issue of the work without permit was resolved and whether or not this was an eligible license. If it was to be overturned, then that would potentially make a 2022 license issuable. And the only other thing that I'll say at this juncture with regard to that is that it's not open to this panel to authorize something that is contrary to the bylaw. You're not sitting as council right now. When you're sitting as council, you of course have the ability to change and alter the bylaw, but right now you are constrained by the bylaw. So in order to allow a permit to issue, you would have to find that this was you would have to determine at this juncture that there is no work without permit and that this was part of the principal residence. So that would be what you'd have to determine in order to overturn the decision and allow a license to be issued.
And my final question would be: is if this panel were to uphold the recommendations made by the chief license officer, I'm just wondering, could it say that the property in question is currently not eligible for short-term rental, and currently would further explain that it's in current time right now?
You certainly could do that. It's unnecessary because I think that that's implied always, but you can certainly do that.
Okay, thank you very much. I will leave it there. I see Councillor Wiebe on that. Thank you.
Go ahead, Councillor Wiebe, and I'll add myself for one or two clarifying questions as well, and then we'll move to closing statements, just so everyone is aware of where we're at.
Yeah, a couple quick questions. What is the process if no notice was given prior to the order?
I'm not sure I understand the question.
It was identified that the clerks had not contacted the homeowners prior to the order being delivered. Is that something that has to be part of the process to ensure natural justice?
No, it's not.
It's not?
No, it is not.
Okay.
There's a specific order power in the bylaw that allows at any time for an order to be issued to provide access.
Okay, so it's not prerequisite. Second, a formal order to comply with the permit. You said it's up to the homeowners to find out what needs to be done to be in compliance and to get the permits in order. If this is a life and safety thing, wouldn't the city want to be working with the homeowners to make sure that it's a safe place for them and their family to live in?
The city would, of course, work with them. It's just that the process needs to be initiated by the homeowner.
So recognizing that we know that the property might not be safe, it's not our responsibility to work with them to make sure it's safe.
We would issue the order and we might move forward, but then they need to, they're the ones who are in control of coming in to apply for the permits and to identify and to determine in what manner they want to regularize it. Because at this juncture, we don't actually know what they want to do in particular. We can say, look, these aren't on the plans, but we can't generate, the city can't generate the plans and can determine what exactly they want to do with their property.
Okay. Is a primary residence not allowed to have 2 kitchens?
No, you would not get planning permission under a development permit or the like to have 2 kitchens in a single family dwelling.
So, okay. And what's the reasoning for that?
Prevent illegal suites as much as
Okay.
anything.
Interesting. That's all my questions.
Thanks, Councillor Wieben. I also just wanted to clarify, and Mr. Dixon, I'm aware this is sort of a bigger city process question, but interested to know what the homeowners' options are, what the supports at the city are to meet with them and help lay out options after this. It's clear there's a lot of confusion. I think we all understand that city processes can be confusing for any of us. So would the next step be to reach out to the planning department, or what?
There is a whole established process for regularizing illegal suites. People go through it on a fairly regular basis. I don't have at my fingertips exactly how that process works, but my understanding is that you would go in and meet with the building department and say, I want to regularize this suite. There's an application fee and a comprehensive inspection that gets done that initiates that process. Okay, so the licensees could follow up with council or reach out to city staff. Yes. So, and just to clarify that, part of the reason for that is that the person who did this inspection is a property use inspector, and the property use inspector simply looks at the plans and says this doesn't conform with what we have on file. In order to regularize it, you need a building inspector, a plumbing inspector, an electrical inspector to be able to have a look at what's actually there and say, okay, that's actually fine, that's fine, that's fine. You just need to apply, but what you have here, it doesn't require any upgrades or any changes. The property use inspector doesn't have the necessary expertise to do that. Okay, and the panel wouldn't need to give direction in a closing motion for staff to meet with the licensees. Those processes exist, and we just need to make sure. At that point, and I can offer at this juncture that Koji and I will provide the appellants with some information about how they go about regularizing those suites at the conclusion of this, regardless of how the panel decides today. Okay. Appreciate that. So I have one more process question for you, Mr. Dixon, which is the licensees have a clarifying question as well for you. Is it appropriate for them to ask that question through me as chair? If they wish, or they can ask it directly. Okay.
Okay, thank you. In the business documents, inspection report, page 8, under the recommendations, it says that zoning and development letter to apply for the required permits to either remove or retain the unapproved alterations within 60 days. This has never been sent or received on our end. Is that 60 days?
So for clarity, that you don't want to get that letter. To be honest with you, that's the letter that initiates which is the first step of our enforcement procedure, which eventually leads to prosecution if it's not done within that time. It's preferable if you're not. They've elected not to proceed down that road.
Okay. Thank you.
Okay, thank you. So we're moving now to closing submissions from City of Vancouver Council.
I think you take my point at this point. The suspension was issued as a result. This is an unfortunate situation in terms of the work without permit in the building generally. That's a circumstance that crops up not infrequently in Vancouver for the reasons that the appellants said. It's just simply not a great deal of time when you're trying to buy a house in the current Vancouver market, and unfortunately people get caught in these types of situations where they're not aware illegal work without permit in their house. It can be brought into compliance. It will cost some money to do. But so at this juncture, because of that work without permit, the city's not in a position, and this panel's not in a position to issue a license. The bylaw is very clear that a dwelling unit that an illegal dwelling unit or an unpermitted dwelling unit can't be licensed as an STR. As a secondary issue, there is the issue about whether once it gets brought into compliance with the zoning bylaw and the building bylaw, et cetera, whether or not it would then be eligible for a short-term rental license. And the appellants have raised some interesting questions with regard to that. As it currently is constructed, it's my submission it would not qualify right now because of what is clearly a kitchen right now. Obviously, that kitchen area could be reduced and maybe something that they wish to reduce in order to allow them to do that. I don't know what value. That's a choice for the appellants to make. But as it's currently constructed, even if it was eligible, even if it was not work without permit, it wouldn't be eligible for short-term rental because it's not the primary residence. The separate unit, which we would define based on the kitchen, is not a separate unit. You don't have to go down that road because the work without permit for 2021. What appears to be my submission is the appropriate course of action at this juncture, and in my submission you are constrained by the bylaw, is to find that this is not currently eligible for a short-term rental license, this property, but that there is no reason, and if you can put this in your decision if you wish, there's no reason that once the work without permit is resolved, that they can't apply again for a short-term rental license. And then we would, of course, do a new assessment about in new circumstances. And that's basically the city's submissions with regard to this.
Okay, thank you, Mr. Dixon. Are there a reply or closing submission from the licensees?
No, I think we've said everything that we can say in the matter, and we just ask that obviously, yes, we understand the circumstances here. We are willing and able and have shown that we want to work with the city. Obviously, we are trying our best to figure it all out ourselves as well and learning quite a bit. Yeah, and we're hopefully being able to come to some clarification and some amendments that allow us to function in the process that is now going to be months and months and months. It's in potentially years. I have no idea, but it's not going to be something that will be rectified in a given week or two. So yeah, that is unfortunately the nature that we're in. We've inherited this. But it is a very safe house, and I would not want my family living in an unsafe house. We had it inspected. We're willing to go through the processes, but hopefully, in this circumstance, we can come to some, mutually beneficial to some degree agreement. But yeah, we'll leave that judgment for you guys. Thank you.
Thank you. And so we're moving to discussion from the business license hearing panel. And I see Councillor DiGenova on the list. Go ahead, Councillor DiGenova.
Thanks so much. I've taken the liberty of just adding, and I'm hoping maybe through you, Chair, Mr. Dixon could take a look at this, but at his recommendation that it wouldn't be out of order to add something that just further offered assurance that there could possibly be another application if this was brought into compliance. I have sent in a motion, so I've circulated that through our meeting amendments, and I've also copied Mr. Dixon on that. I'm happy to read that out and then speak to my reasons why, unless you'd like a moment to review that, Chair.
I am just seeing it, and I will ask legal if the wording is.
I've had a chance to review it, and I would simply say that, Councillor DiGenova, the first statement that the business license hearing panel, it should be uphold the suspension of the 2021 business license.
Okay, all right. I'm happy to do that, Chair. If perhaps I could have a recess just for 2 minutes, would that be all right?
Yes, sure. Let's make sure that we're doing this properly. So if you want to draft that, we'll just take a 2-minute.
Thanks very
Recess.
much. And I just wanted to clarify, if I could, before that recess, that Mr. Dixon had said that it should say the business license hearing panel uphold the
Yes.
decision of the chief license officer.
License inspector to
Sorry.
suspend. Yes.
Chief
And
license
I would clarify that it's the 2021 business license as well.
inspector to suspend the 2021 business license. Is that correct?
Yes.
All right. I'm going to try this again. And Mr. Dixon, I will copy you on this.
Thank you.
Councillor
DiGenova, do we need a 2-minute recess?
I don't think we do anymore. I'm sorry for that procedural misstep there. And I will put this forward. It hadn't been seconded, so it would now read, and maybe I'll give you a moment to review that, Chair, as well as Mr. Dixon. Apologies for any errors I have from typing on the fly.
Thanks, Councillor DiGenova. I am just reviewing it. And I will just check with Mr. Dixon that the language is appropriate and in order.
Yeah, it is.
Okay, so I will read it if that's all right, Chair.
Yep. Go ahead, Councillor DiGenova.
So, and then I will comment on my reasons for bringing this motion if it's seconded. That the business license hearing panel uphold the decision of the chief license inspector to suspend the 2021 business license, known as business license, issued to Daniel Pikachu, I hope I got that right, and Sheena Graham, the licensees, for a short-term rental accommodation at 1351 East 19th Avenue in Vancouver, BC, on the basis that the property in question is not currently eligible for short-term rental under the City of Vancouver's license bylaw number 4450. Furthermore, if brought into compliance, apologies, I just lost that. Furthermore, if brought into compliance, there is no reason 1351 East 19th Avenue, Vancouver, BC would not be eligible for a short-term rental license under the City of Vancouver's license bylaw number 4450. And I'll wait to hear from you if we can move forward with that motion, and then I'll comment on it, Chair.
Thanks. Do we have a seconder for that motion?
I can.
Thanks, Councillor. We've seconded, so go ahead, Councillor DiGenova.
I just wanted to say to the licensees, Daniel and Sheena, if I may call you that, I really do empathize with the situation that you're in, and I really do appreciate that you tried to be proactive and do everything you could, and you did not operate when you were not in compliance. You ceased to operate, and I do appreciate that, and I think that shows a lot of goodwill. Unfortunately, because we sit in a quasi-judicial body and we have to consider the legalities of our bylaws here, although I understand that the process may not have been as clear cut, and I had some questions as well, I would hope that this gives you assurance that although we have to uphold our bylaws at the City of Vancouver, there's no reason that you cannot move forward and come into compliance. And I hope that you will be able to take those steps. I understand that it is more of a process, and I also appreciate the fact that our staff, from legal and licensing, have offered to help you find your way through that process or to that process. Unfortunately, because this has come before us, we have to rule based on the merits of what we have before us in the evidence package. But I do hope that this will offer you the tools that you need to move forward to come into compliance. And I very much appreciate how open you've been and proactive you've been in what you've tried to do in making sure that you abide with the bylaws of the City of Vancouver. That's all from me for now, Chair.
Thank you, Councillor DiGenova. I don't see anyone else on the list, so I'm just going to echo myself that we are certainly conscious of how both of how stressful housing and real estate are in Vancouver and how complex some of these permitting issues can be. That's not isolated to this incident, and it's an issue we all think and worry a lot about, and that the city is working on a number of fronts to try to clarify. So as Councillor Deitchnova articulated well, I think we are all sympathetic to these challenges, absolutely, and keen to figure out the appropriate pathways of support that make it easier, while of course being conscious of our, in a quasi-judicial hearing, our obligation to be upholding existing bylaws without a lot of wiggle room while that work happens as well. So I'm just checking, Councillor Wiebe, anything to add before we move to a vote?
Yeah, just quickly, I appreciate everyone who spent time, and the ideas that have been brought to the table, because it has highlighted some issues we do have and some process work that we can work on. So I really appreciated this process, and hopefully we can find a resolution moving forward. So thanks for spending the time and doing your research, and being forthcoming on everything you've done, and appreciate staff's time on understanding the issue and working through the process. So I will be supportive.
Thanks, Councillor Wiebe. Okay, panel, we are moving to a vote. I'm just going to do a verbal vote and ask all in favor to say yay.
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 Yay, and any opposed? So the motion carries. That concludes this business license hearing, and appreciate the work that has and thought that's gone into it, and the follow-up that we have heard will happen next. I don't.
Motion to adjourn.
Yeah, exactly. That's what I was going to ask. A motion to adjourn. Thanks, Councillor Wiebe. Thank you. All in favor?
Aye.
And any opposed? That passes. So we're adjourned again. Thank you, everyone, for this virtual hearing. And have a good day.
Thank you.
Thank
Thank you.
you.
Thanks,
Bye-bye.
everyone.
Thank you.
Thanks, Ian and team.